In a relief for Tata Trusts, the Income Tax Appellate Tribunal has upheld the tax exemptions which were given under the Income Tax Act while dismissing revised assessment orders issued by the Tax Department. The ITAT also dubbed the documents submitted by Cyrus Mistry as doubtful and quashed Income Tax Department's revised assessment orders for 3 Tata Group trusts. The Income Tax Department had intended to cancel the tax exemption which was given to 3 Tata Group trusts on the basis of material which was given by Cyrus Mistry intending to revive tax assessments. ITAT has upheld the original assessment orders which had exempted Tata Trusts from any tax liability as per Section 11 of the Income Tax Act. The ITAT noted that Cyrus Mistry, a former chairman of the Tata Group, was removed from his position in the Tata Group on the 24th of October 2016, and within 8 weeks of his removal, he sent this material against the trusts in the Tata Group, including the assessees which were before the ITAT, to the assessing officer. The tribunal questioned the objectivity of the documents submitted by Mistry, which appeared to be doubtful in the eyes of the appellate tribunal. Also, the court noted that the action of supplying documents to the Income Tax Department without any authorization of the company, even though they were apparently obtained by Mistry in the fiduciary capacity almost immediately after being removed as chairman of Tata Sons, cannot be taken to be influenced by a call of pure conscience and a high ground of morality. Since Mistry was the chairman of Tata Sons Limited since 2013 and its director since 2006, the tribunal noted that he knew everything very well but kept quiet all along on the basis of the claims which he had made later. Also, it was observed by the tribunal that this kind of conduct which was displayed by Mistry was unheard of in the civilized corporate world, and noted that the inputs taken from those engaged in a rivalry with a tax assessee should be taken with a reasonable degree of circumspection and should not be placed on such a high pedestal so as to relegate all other material facts and past assessment history of the case into insignificance. Also, the tribunal noted that the assessing officer had received this material on 22nd August 2016 and had just 6 working days to complete his assessment. Also, the tribunal noted that the assessing officer was not in a position in course of completion of scrutiny of assessment proceedings to examine the correctness of the contents of the material which was submitted by Mistry. Also, the tribunal noted that there were several issues which were ignored as part of the documents which were submitted by Mistry, on the basis of which the order was passed in favor of Tata Trusts. The tribunal noted that the business model of ownership of Tata Sons, a holding company having investments in the group companies, is somewhat unique in the sense that the majority shareholding in this holding company is collectively in the hands of various charitable institutions, including the trust before the court, and the Articles of Association of Tata Sons, in recognition of this ownership model, had granted certain rights to these charitable institutions on a collective basis.